Here's another guy who just keeps going and going and going in the name of civil rights. Clayton Ruby first appeared on the scene, my scene of awareness in the early 70s, which is about the same time we launched City TV. And I began to notice Clayton appearing regularly on our evening newscasts. The cases he took on were not only consistently interesting, but many of them were symbolic, including one, and I hope I've got this right, Clayton, where you argued for gay and lesbian rights in the Canadian military on behalf of the partner of our next speaker, Irshad Manji, have I got this right? In opposition to the Canadian military, who were at the time led by General Chastelet. And what I'd like you to know is that Clayton won, and John was very happy about it. Clayton Ruby. Thank you.
It is like old home morning today because though John and I had ever met before, I indeed did sue him on behalf of Irshad's partner, a wonderful woman named Michelle Douglas, who some of you may know, a woman of great courage and integrity. And the interesting thing about that was that after years of struggle, when we got to the courtroom door, the armed forces and the government of Canada, through John de Chastelain, admitted quite openly at that point that there had been discrimination against gays and lesbians in the armed forces, that it was unconstitutional and wrong, and he gave the order that it was to stop. And it has stopped, to your credit, and I think we're all grateful for that. There was a court order, but there was a military order too. Henry Morgentaler is the guy who, when you walk down the street with him, everyone says, "Who's that guy with Henry Morgentaler?" Henry's a 30-year friend and client. We share a bit of geography in that my paternal family comes from Lodge, and Henry can remember the street in the ghetto where my family lived, which he remembers as being called Rubleski Strasse, the street where the Rubies all live. And it doesn't appear on a map, but in his head at that time as a child, that's what they called it. And we've been, as I say, friends for a long time, and I've had the privilege of trying to assist him too. It's interesting to contrast that kind of personal relationship which emerges out of a struggle, and to look at people like Henry, whom I've always, you don't understand with him how it is. He's slight, he's frail, he's often not in good health. And whether you're his lawyer saying to him, "Henry, don't do this. Don't put yourself on the line once more. Let somebody else do it." Or whether it's a government saying, "If you do this, I'm going to put you in jail." And you wonder where that strength comes from. And I think it comes from growing up in a concentration camp. I think it comes from that place inside that says, there is nothing that you can do to scare me. I, on the other hand, scare quite easily. And I want to talk just briefly today about two things that do frighten me. One is our commitment to equal justice. It's something we've talked about a long, long time, and we all think we know what it means. But I think it's become eroded to the point where saying it is a lie. Let me explain what I mean. Some time ago in this province, we established a legal aid plan, which was to provide for criminal defendants at least, and to some extent for civil cases, payments for those who could not afford to pay themselves. And the payment level is crucial, because without payments at an appropriate level, you will not get lawyers working, or you'll get different kinds of lawyers working. The level was designed, intended, and promised to be that which a client of modest means would pay for the services that were required. And that went on with modest increases to keep up with the cost of living until its present level, $64 an hour for young lawyers just starting out, and 87, I think I got the number right, for lawyers with, in my case, 30 years of experience. And that number's remained the same since the late 1980s. Nothing. Police get raises every year, Crown attorneys get raises every few years, but defense lawyers have gotten absolutely nothing. The other level of civil involvement is immigration cases, family child welfare cases, custody cases. That's the civil legal aid, and they're at the same rate. Meanwhile, the level paid to lawyers has surpassed all that to the point where most lawyers, the overwhelming number of lawyers, do not take any meaningful part in the legal aid system. It's easy to blame lawyers for that, but the truth is it's the government's fault. The lawyers can't afford it. When I take on a legal aid case, and I take on as many as I can afford to take, it costs me over $100 an hour out of my pocket every time I do an hour's work, just to pay the overhead. Not to earn anything, but to pay the overhead. What does this mean for poor people? It means that we've developed a small legal aid bar, mostly young, many inept and incompetent, who provide, of necessity, second-rate services to the poor. Now, to their credit, they provide them when nobody else would. But can we not feel utterly ashamed that we have allowed this to happen? So, for example, they are lawyers who, because of the low rate of pay, often have no offices at all. They can't afford rent. They practice out of their homes. One practices out of a truck. Second, they have no secretaries. And what that means is that they can't do the now labor-intensive, paper-intensive work of motions and affidavits for constitutional breach to assert their clients' constitutional rights. You just can't do it, so they don't do it. So poor people don't get constitutional arguments made on their behalf. And thirdly, of course, they have no libraries, no law libraries. And they don't take the time to go down to the public library. So the quality of the learning they bring and the amount of preparation they're able to bring to bear, all of it's second rate. I'm appalled by this, just utterly appalled, because we've allowed this to build up without any significant protest. Recently, there was a one-day study session in Toronto to try and build support on this issue. It dropped into the lake of government indifference and cutbacks without a ripple. Now, in a number of small towns, places like Quinte, the local bar is saying, we're not going to take legal aid certificates at these rates. We're going on strike, in effect. The press has paid very little attention. I'm talking about it today because I think it's vitally important. I think if you don't pay lawyers properly so they can do a decent job, you wind up with an underclass of second-rate service in the criminal justice system and amongst civil law. One of the things that really hurts me most is I get about 3 or 4 calls a day, and I'm one of 30,000 lawyers in Ontario. And these are people who call up and they've got a problem with government or a hospital or an agency that's not treating them properly, and they say, can you help me? And the answer is mostly, I cannot. There is no legal aid for this. They are poor people, and the government says essentially, go fuck yourself. We don't care. We'll provide nothing for you. And they have legitimate, serious problems, many of them problems that affect not just themselves, but thousands of others in similar situations. And there is nothing for them. And we should be ashamed of that. Tied to the idea of equal justice is the idea of equal justice for all, even the meanest and most despised among us. Let me just turn to that for a minute. DNA evidence has turned out to be, in my view, in any event, the best thing since sliced bread for the criminal justice system. It has a very high accuracy degree. It is useful in clearing people as well as convicting people. I I find nothing that you can argue against it. There are dangers, of course, in that you must make sure that there's no contamination of the samples you are analyzing. That requires more skills on the part of the police officer than we traditionally see, but that's something you can train for. And it's something that you can try and allow for in cross-examination and catch if there's a problem. But by and large, it's the best thing since sliced bread. And it's meant, as you must know from reading the papers, that in a number of high-profile cases, people who have been locked up for murders and other crimes of violence for many, many, many years have been freed because the DNA analysis done, now that we've developed the techniques, now working on smaller and smaller samples and more accuracy, have shown that they are indeed innocent. There is a problem with the scientific advance of DNA evidence in the judicial system. And that is that it has, in effect, raised the bar for showing a miscarriage of justice. Unless you've got DNA evidence to prove your innocence, people tend to say, well, you know, we're really not interested. And there's a mechanism which the law has always provided for those who were wrongfully convicted, and it's in Section 690 of the Criminal Code. And essentially what it says is that you make an application to the Minister of Justice for the mercy of the Crown. It's rarely taken, but it's taken with some small frequency every year by a number of people. And they've got to marshal evidence to show that they were in fact wrongfully convicted. Back in the Donald Marshall inquiry many, many years ago, the first recommendation, and therefore the most important of that Royal Commission, was not that Donald Marshall be compensated. The first recommendation was that the mechanism in the Section 690 application should be taken from the Justice Minister's office and the Justice Minister's employees and made an independent agency. Kim Campbell rejected it. Subsequent Justice Ministers have rejected it. Nothing has happened. So when you've got a problem like this, you must make application to people who spent their life prosecuting cases. The investigation is not done by independent investigators. The investigation is done by people who are trained police professionals. Or you gather your own evidence. There is no budget to assist anybody. Taking it out of the Minister of Justice's domain and making it independent would encourage people to come forward. I acted for Donald Marshall in the Royal Commission of Inquiry that cleared him and investigated the wrongdoing and how it had come up. And one of the witnesses who just touched my heart said, let me tell you what happened. He said, I gave the evidence, the police assured me that he was guilty, so I said I saw him in the park doing the murder. And it wasn't true, but I thought there were others who had seen him, so I thought it was okay. And I did nothing for 10 years. And when the police officer finally came to interview me, the first thing I said was, I've been waiting for you for 10 years. We need an independent investigatory agency to look at miscarriages of justice, because a large number of them are not cut and dried. They're not DNA cases. The most usual cause of miscarriage of justice is wrongful identification. Honest people like you and I who believe that, yes, that's the man, but who are just wrong about it. The second highest cause is police officers who are certain they have the right man and encourage, beat, threat, force, entice other witnesses, often young people or weak people, to give false evidence. Way down the list is things that can be corrected by DNA. That's an unusual case. So we're failing those who are the least of us, who have been imprisoned and convicted of heinous crimes. And it would be so easy to make that agency independent, fund it properly, take it out of the Justice Department, and put it in proper hands. We don't do it. Part of this is a pattern that you might see. It is the underfunding of public institutions in this country. It is the notion that if it's public, it's okay to be second rate. And I say to you, it is never okay.